Welcome to Sakshi TV's special immigration show with attorney Ms. Prashanthi Reddy from Law Offices of Prashanthi Reddy PLLC. Please note that Sakshi TV now has 3 immigration shows every week on Tuesday at 3 p.m. EST with attorney Ms. Sheila Murthy, Wednesday at 5:30 p.m. EST with attorney Prashanthi Reddy in English, and on Friday at 6 p.m. EST with attorney Bhanu Ilindra. Please tune in to ask your questions. If you're an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice and is for general informational purposes only. Sakshi TV or its agents will not be responsible for use of information. If you need specific legal advice, please contact the attorney directly. Ms. Prashanthi needs no introduction. But if you need consultation, please log on to readyesq.com for contact information. And when you connect with them, don't forget to mention Sakshi TV. From the beginning, readyesq.com has put a wealth of free information and online tools in the hands of immigrants, community, and for the benefit of US employers. The readyesq.com site provides you with latest and cutting-edge information on US immigration law and policies explained in terms you don't have to be a lawyer to understand. Today's topic is the H1B alternatives. We will continue the knowledge session along with the news updates and latest immigration followed by Q&A. Before we get into the topic, you can call us on the numbers on the screen for questions related to immigration and also ask for tips. Hello Ms. Reddy, how are you doing?
I'm good, thank you. How are you, Tony?
Very well, thank you. So it's winter officially and we're heading towards the holiday season. So we'll get started right away with the topic, Ms. Reddy. Could you please explain to our viewers about the H1B alternatives?
Yes, so as you all know, we started on this topic last week, but we did not complete it. So we've decided to have this session on the alternatives to H1B. And it's very apt and very key for this time in this season because as you all know, the CAP season is over. Registration took place last March and there was a final pick of H1s. We don't know if it's the final one or not, but there was a third lottery that was held for H1s, and the deadline to submit documents for that third lottery is January of next year. So, you know, it's an apt topic to discuss. With reference to the holiday season, we did discuss travel and the COVID restrictions, etc., in our last topic. So I thought this time let's talk about alternatives to the H1B.
Right.
So I guess the first alternative to the H1B would be if you are working for a CAP exempt organization. So if you're working for a CAP exempt organization, you don't have to worry about the CAP, meaning you don't have to worry about filing for registration in March and then hoping to get picked and then, you know, then subsequently filing for the H1 as per the deadlines that are given by USCIS. So a CAP exempt employer can file a H1B at any time because they're not subject to that CAP requirement. So who is a CAP exempt employer is the next question. So a CAP exempt employer is an institution of higher education, like a university is an institution of higher education, or a non-profit entity that's related or affiliated to an institution of higher education. So like a working hospital, if they have an affiliation, so for example, Cornell Hospital has an affiliation to Cornell Medical School. I'm just giving you an example. So that Cornell Hospital would be a non-profit related to or affiliated to a higher education institution. So most hospitals or the big hospitals do have affiliations to colleges as well. So they become CAP exempt employers. The third category, the last but not the least, is non-profit research organizations. So research organizations, and they cannot be private research organizations, they have to be either non-profit research organizations, that means they cannot be for-profit, or they have to be government research organizations. So you have institutions of higher education, you have non-profit organizations that are related to institutions of higher education, and you have research organizations which could either be non-profit or governmental. So those are the different types of cap exempt organizations. Now, something to keep in mind is, especially if you're in the IT business and you are working for an employer, but you're actually placed at a third party site, it could be that your end client is cap exempt, because you might be working for a private consulting company, which is obviously not cap exempt, but if you're placed at a hospital or a research organization which is non-profit or governmental, then or a university, educational institution, then you're still cap exempt. That's something to remember. It's not just the employer has to be cap exempt, but they've expanded that definition to mean place of work. So it could be the end client also that's cap exempt. So keep that in mind, that anyone who has a cap exempt end client can also make use of this benefit. The only disadvantage of this is that if you then move to a regular employer like a consulting company that is not cap exempt, then you will have to then file a H1 through the cap, because you were never counted towards a cap. So say you worked for 3 years for this university and then decided to go into industry. In order to go into industry, then you'll have to file a H1 through a private organization, and then so you will become cap subject, and you'd have to then file it in March. I mean, go through the registration process, and then if you get picked, file it before the summer or whatever the deadline is. So the next alternative for the H1B is the O visas. The O visas are generally reserved for individuals who have extraordinary ability in the sciences or in the arts or in education, business, or athletics. So as you can see, the scope is rather limited. Not many individuals qualify for the O visa, but where possible, an O or P could be prepared in lieu of a H1.
Right, so they're all only based on extraordinary ability then.
That's correct. Right. So in addition to be able to obtain work authorization based on this O, the O could also then establish a path towards EB1 category for green card. And we know there are the 3 EB categories, and we know right now EB1 is current for Indian nationals. So EB1, that's invaluable to be able to qualify for EB1. So because the criteria is kind of similar. So basically, if, for example, you're working as an executive chef and you are well known, you have done various shows, you work in, you've won many awards, you have press, there are a lot of celebrity chefs. And if you have a following, then you could be, for example, an O1. You may not qualify for a H1 because it's during cap season, but you may qualify for an O1. In the same way, if you are an IT professional, of course you qualify for a H1, but you might also qualify for an O1 if you have some products or processes that you have, patents over, that you have, and like you've developed an app and it's become really popular and it's extremely useful for the common public. So you can always try to show, so then you could show that's the extraordinary ability in the sciences. Of course, you have to show press surrounding it, you have to show your success, how successful the app was, how useful it is, etc., etc. So there are possibilities of an O even in the IT scenario. You could be, maybe you developed a methodology or a process to make things easier. So it could be anything. It doesn't have to be a product or a software. The third and I think most important alternative to the H1 is the L1. So the L1 is also called an intra-company transferee, and this is the most useful because number one, there's no cap. It's not subject to cap. Any number of L1s can be filed in a year. Number two, there is no minimum wage requirement. So unlike the H1, which has a prevailing wage and the employer has to pay that prevailing wage, there's no prevailing wage for an L1. As long as it's a reasonable salary, that is sufficient. And last but not the least, the dependents of an L1 are automatically approved for employment. L2s are automatically approved for employment.
But
So
if
they
there's
don't even
no
have to file
prevailing
an
wage,
EAD.
Miss Reddy, wouldn't that be a problem for all the L1 applicants, as in because for O1 and the cap exempt visas, there is a prevailing wage for the H1 visas and all. So wouldn't that be a problem, just in case? As long
That's actually
as
not a problem. That's one of the
right,
problems has been solved.
right,
I mean, it's a problem, meaning it's unfair because for the L1 you don't have it, and for the H1 you have it.
right,
And I mean, the criteria should be the same if the Labor Department is trying to make sure that U.S. businesses are not trying to get cheap labor, then um, they should have the same requirements for an L1. But I'm not complaining. Um, but yes, it has been criticized because multinationals are in fact they get people more than H1s, they use L1s, and they bring people on L1s, and they pay them Indian salaries. They pay them salaries back in India. They don't even pay them the salaries here. They bring them in bulk on L1B because if they have a blanket L1 petition approved, um, they don't have to file a petition each time with USCIS. They can just go take the blanket L1. The particular candidate has to take their documents to the consulate and they approve it or process it at the consulate. So most of your MLCs bring in the bulk of their employees on L1B, I must say. So there's a difference with the L1, the L1B and the L1A. The L1A uh, is for multinational executives, so only executive and managerial positions. And the L1B is for people with specialized knowledge. So the advantage of the L1A over the L1B is L1A qualifies for EB1 and you can file directly an I-140, whereas L1B you have to go through the regular route of labor certification,
right. The
I-140,
process, yeah,
EB2, EB3, etc. Yeah, and you get it only for 5 years as opposed to the L1A, which is for 7 years.
right,
So the L1A is basically, as I said, a managerial or executive position. So the first requirement is that the company should have, the US company should have a parent or a subsidiary outside in a foreign nation. So, for example, in India, and that employee should have worked in that Indian company for at least 1 year out of the last 3 years. And the work should have been, again, executive or managerial in nature. So that's the criteria. So it's important. There's a lot of documentation involved. You have to show that both companies are related to each other, how they're related. You have to show that both are doing business, the India as well as the US company are doing business, have a premises, have a running business. So there's a lot of documentation involved. And then showing that the work is executive or managerial. It's not just a statement. That is not sufficient anymore. They're asking for actually documentary evidence of managerial work or executive work. For example, they might ask for copies of the bylaws showing that the person was appointed as a manager
right.
or a director if it's executive.
So
Or they could ask for shareholder meetings, minutes of the meetings. They could ask for email correspondence or signature of the principal applicant on, say, employment contracts because he's a manager, he's managing other employees, so he's signing their employment contracts, granting them leave,
right,
granting them pay hikes, etc., etc. So there's a lot of documents that have to be shown, but if everything is in place and people have the patience to gather all these documents, yes, it's absolutely a really good option, especially for not just for in lieu of H1, but also for people who are company owners and
right,
really have a share in the company. Then H1 is not a good option for them because you know, with the employer and employee relationship rules, you can't get a H1 if you own the company, but you
Right.
can get an L1.
Ms. Reddy,
So that's the advantage.
yeah. Sorry to cut you off, Ms. Reddy, but with your permission, we have a caller on hold. Ms. Pooja from
Sure.
Los Angeles. Thank you for calling, Pooja. You may ask Ms. Reddy your question directly.
So hello, Miss Reddy.
Hi.
I'm Pooja. I'm calling from Los Angeles. Hello.
Yes.
And my question is to you is that my interview is scheduled for green card since March 2020. I haven't got any update regarding it. So what steps do you suggest I should take?
So you're saying you filed your green card, but you haven't received a receipt?
Yeah.
No receipt
Hello.
as yet?
I can't hear you. Excuse me.
Tony, I think we have a
Hello.
connection problem because
Hi, Ms. Pooja. You could please, if you could please check your connection, please. We're hearing some static along with your noise. I mean, along with your voice.
No, my network is actually very better.
Sorry?
can you hear me, Pooja?
Can you ask my question behalf of you, behalf of me, if you can hear me? Hello.
I'm sorry. I'm afraid we're not able to understand, Pooja.
Tony, I could
Hello.
understand her question, but I think she cannot hear me.
Pooja, if you cannot hear Miss Reddy, if you cannot hear Miss Reddy, I hope you go back to the show and watch it again. It will be telecasted. Miss Reddy, if you could please give her the answer, I'm sure she'll find a way to watch.
Yes, it's on YouTube,
Yeah,
so
it's
you
on
could watch it
YouTube,
later
right?
on if you can't hear me. But Pooja, a lot of people are in the same boat as you, and if I understand correctly, you're asking that you filed your green card application. I'm presuming you're 485, but you have not received any responses yet. You should get a receipt in about maximum a month. Check for make sure you, if you're not getting the receipt, then if you didn't get it, make sure you check your bank for the look at the cancel check. So if you get a cancel check and if the check was cashed, then at the back of the check there will be a receipt number, and you can then follow up on the USCIS website using that receipt number. So if you haven't received a receipt, you can see if your check was cashed. Otherwise, I'm afraid if it's been more than a month, it's possible that maybe your case is coming back. Maybe there was it was sent to the wrong address or a wrong check was sent. There could be many reasons why a case is sent back. In that situation, they will not fee receipt it, so you will not get a receipt and they will send the check back.
Right. I hope that answered your question, Pooja. Thank you for calling. So, Miss Reddy, you were telling us about the L1.
Right. So I think, yeah, so L1 is a good option. So
Yeah.
if anyone has questions, you should reach out to your attorney with reference to how it actually works. And moving on then, Tony, to the next one it's the TN visa. And this is a great, great option for Canadian and Mexican nationals. Now, the TN visa for Canadian nationals and Mexican nationals is based on designation of occupations. So there is a set designation of occupations, and if you fall under that designation, and if you qualify under the educational requirements under that designation of occupations, then you basically will get the TN. The TN is a little different from for Canada and Mexico. The Canadian TN is based. You can get it from the port of entry itself. You do not have to go for a visa. You do not have to apply for an I-129. So you can go directly to the port of entry and get the Canadian get a TN visa. So you can go to the airport, or if you're traveling by car at the port of entry, you can do this. So the only documents that you have to submit for a TN Canadian visa is proof that you qualify. So a memo has to be written showing how you qualify. your educational credentials, and if required, an evaluation to show that you qualify, and an offer letter from your company, proof that you actually have a job. So it's a pretty simple requirement for the TN. For TN Mexico, as opposed to Canada, you actually have to go to the consulate and apply, so you can't apply at the port of entry. So this is a great option again for in lieu of the H1, in fact better than the H1, because there's no minimum wage. I mean, minimum wage has to be paid, but there's no prevailing wage, right? Prevailing wage is often much more than the minimum wage. So as long as it's a reasonable wage, they will accept it. And it's a great option because the process is not lengthy. You only have to go and apply at USCIS or with USCIS if you're filing an extension while you're in the country. And not many people do that because they just prefer to go out and get, a renewal rather than filing the I-129 application with the USCIS. So TN is really a great option.
Right. So we also have our other countries' specific visas coming up for the next, H1B alternatives.
Yes. So our other options are all country specific.
Right.
So depending on the country, there's some special options for certain countries. So for example, Singapore and Chile, they have the option called the H1B one, and they have a separate cap, which is not included in the general cap. So that cap is usually not used up. So I mean, pretty much H1 for Singapore or national from Chile is always available. So that's great if you maybe you can get citizenship in Singapore or Chile and then get the H1 that way. That's another way of doing it. So depending on how easy or difficult it is to get citizenship in those countries. So the requirements for a H1B1 are pretty much otherwise the same as a H1B, specialty occupation requirement, offer of employment, etc. The other option is the E3, which is again great if you're an Australian national. So it's for Australian nationals, and again, you don't have to go to put a petition with USCIS first, get an approval, and then go to the consulate. You can go directly to the consulate and file an E3 at the consulate. Not at the port of entry, you have to go to the consulate. So again, very easy, same requirements as a H1, but much easier because there's no I-129 forms or USCIS pre-approval involved. So just a petitioner letter, an LCA approval, and documentation to show that you qualify for a specialty occupation, employment contract, etc. Is sufficient. Educational credentials is needed in your package when you're going to file, for the E3, and usually these cases get approved. I haven't seen much issue with them. So, again, another way to come in if, there are a lot of people who try to get in through the cap and they don't make it at the first attempt, second attempt, third attempt. Then you have to try something different. Then maybe try for Canadian nationality, which is easier to get, or some other country, and then find an alternative way, or try for an L1. It's not just the fact that a H1B cap is limiting because they get over, but also because during the registration period, 4 times the amount of people register. So it's a lottery really. So whether you'll get in or not, and there are many people who don't get in even after 3 or 4 attempts. So that's why these alternatives are important.
Right.
So the next one is the E1, E2 treaty trader or investor alternative. Now this is again for only certain specific countries.
Right.
And there's a list of countries. Bangladesh is one of them. I think Pakistan is also one of those countries. India is not. So again, and then Egypt and Turkey, and there's a bunch of countries that are that have signed, a mutual treaty agreement with the US. So again, if you're an Indian national, then it's not a bad idea to look into getting nationality from these other countries. Yeah, I mean, again, you have to look into it and see whether it's worth it for you or not.
Right.
But definitely an option, especially if you are a businessman. And then, so employees of, um, if you're an employee of a company and you would have otherwise filed for a H1, this is definitely an option. So the E1, there's two types of visas, the E1 treaty trader and then the treaty investor visa. The treaty trader visa is suitable if the foreign national has a multinational employer who is willing to transfer them, and that company has significant trade between the foreign country and the US. So any multinational, in lieu of the L1, they can apply for an E1. And so that employee must have the skills which are needed, to operate the company. And also the dependents of an E1 are eligible to work, which is great, again, like the L1. The other E visa is the E2 treaty investor visa, which allows foreign nationals to invest a substantial amount in the US and obtain the E2 visa, and they should be able to manage and direct that investment. It's not just passively investing into some property or something like that. They should be actually directing the investment. So it has to be into some business, or if it's a property, then that has to have business itself where they're developing something or building something and reselling it. The amount that's required for an investment generally varies depending on the industry. So it's basically a proportionality test. So depending on how much investment is needed. I mean, if only 150,000 is needed, then that's how much you invest. You don't have to invest 500,000 if it's not needed. So as you know, some businesses are heavy, require a heavy investment, and some don't.
Right.
For example, an IT company doesn't really require much of an investment. Just maybe 3 or 4 months of salary, enough money to open an office and take care of expenses for 3 to 4 months. But there's nothing that has to be purchased, no goods that have to be purchased as such, because basically they're making money from the consultants that they hire. That is their product, the consultants. So there's not much investment involved. But on the other hand, if it's a jewelry business, then there's a lot of investment because you're buying the raw product and then you're reselling it. So diamonds cost a lot of money. So that's a lot of investment.
Yeah.
So it really depends on what kind of business you're into. Again, dependence of E2 can work. So that's a great investment as well. A great option for multinationals or for businesses that are both in the US and in India, since we're talking about India right now.
Right.
Well, actually, sorry, not India, but some other country, but Indian nationals if they belong to some other nationality.
Right. So with that, Ms. Reddy, we come towards the end of our session. I do realize that we have some H1B alternatives left, but we will definitely continue that with our next session. And before we end, the show, I'd like to ask if there's any immigration message that you'd like to give, like a reminder for our viewers.
Yes, the reminder would be, I guess my favorite thing to say is don't try to do it yourself. Immigration is very complex, and I'm not just saying this because I need new business and I'm an attorney. I'm saying this because I truly, truly believe in it, and I've seen people ruin their cases and lose a lot of time and sometimes lose things that they can't get back again. So don't try to do it yourself. Even though it might seem simple, it is actually not. It's a complex process, and there are a lot of nuances to filling out the form. So every step has to be thought out as to how you want to, how it should be responded to. And also, if you're not used to filling out those forms, you could easily make typographical mistakes or clerical mistakes, which will again lead to the denial of your case. So just let the experts do their work, and if you have an immigration case, give it to an expert.
Right. So with that, we come to the end of the show. It was a privilege hosting you, Miss Reddy, and thank you for being on our show.
It was a pleasure for me as well, as always. Thanks, Tony, for being such a good host.
Thank you so much. You're watching Sakshi TV Live with me, Torani Makana. Thank you.